If the president orders a military operation, can an officer who carried out the order be held civilly liable for the resulting damage? The answer to this question goes to the heart of the president's executive power, as we discover in the case of Durand versus Hollins. During the California gold rush of the 1850s, people flocked from the east coast of the United States to California. At that time, there was no transcontinental railroad. Instead, the easiest way to get to California was to first travel by sea to Nicaragua, then west to the Pacific coast, and north to San Francisco. Travel demand was high, and a company that wanted to control the travel business in Nicaragua established the city of Greytown. The United States sponsored a competing travel company in Greytown. Hostilities between the companies came to a head in May of 1854 when a Greytown mob threatened a United States diplomat. Someone in the mob threw a bottle, hitting the diplomat in the face. The mob was also accused of damaging the property of the U.S.-sponsored company. In response, the Secretary of the Navy, acting on the president's orders, sent Captain George Hollins to Greytown. The Navy Secretary ordered Hollins to collect compensation for the damaged property and to get an apology for the diplomat's injury. Greytown officials didn't comply with Hollins's demands, so he bombarded the town and then burned it down. Calvin Durand, an American merchant, owned property in Greytown that was destroyed during the onslaught. Durand sued Hollins for trespass in federal trial court. Hollins argued that he was immune from civil liability for the bombardment because he had been following the president's orders.